Welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And here is Samson's stake. I title it Article 146, Not Dirty Politics Playground. In 2018, I wrote a 10-page article to educate on how the now famous Article 146 impeachment law and its process. This was when the then EC boss, Charlotte Osei, and her deputies were undergoing that sham of a probe engineered by the ugly partisan politics, which, if not checked, will divide this country even more to destroy it. A mere procurement rule breach without evidence of loss or corruption ought to receive ratification by the PPA authority as permitted by law, and never to warrant removal from office of a holder of independent constitutional office. But for political convenience, why will the manifestly unconstitutional and unlawful Sputnik V contract and even matters of audit report be allowed to go for PPA ratification under a regime that sprint-ran the originally nameless, faceless EC impeachment petition? I'm even baffled that a most incompetent petition was entertained and later dismissed by wasting ink and good legal research on 11 and one long-page paper. A surface joke of a petition for the removal of the Chief Justice should be the last of such frivolous Article 146 petitions to survive 24 hours in the office of the President, the CJ, or the Council of State. This will be avoided if the Supreme Court's advice in 2005 for the passage of rules and regulations to govern the Article 146 process is heeded. And now, I invite you to read my piece all about Article 146 to appreciate that the provision is not only the constitutional means to remove a judge of the Superior Court or commissioners of independent constitutional bodies such as SRAJ, NCCE, and EC, but also a key safeguard of the independence required to secure their very sensitive jobs. It is obvious from Article 146, Clause 1, that it is intended to avoid a situation where holders of offices of these sensitive democracy-protecting institutions are insulated from being unnecessarily and mischievously disturbed with petitions that are frivolous and intended to abuse the process. It is easy to contemplate how a jilted lover or a bitter spouse or a political adversary would have used Article 146 or be sponsored to activate it if they didn't need hardcore evidence but could only rely on mere gossip to trigger impeachment. It is equally not difficult to imagine what the attrition rate would have been for such office holders or the disinterest for these jobs if mere shouts of misconduct without evidence would get a trial. So, the prima facie stage requires evidence of the facts alleged to be of sufficient weight to justify the need to investigate the matter. In this case, not a single piece of evidence was offered. It ought to have been trashed the moment it hit the desk of the President because it was dead at birth. How do you put a person on trial simply because someone has thrown words on paper accusing another person of a crime without any evidence at all? You have heard a lawyer allege just allegation without any proof that his former client told him that the CJ demanded 5 million Ghana cedis bribe in a case the CJ ruled against that former client. That's all. And you shout, probe him. What a joke. I have described the president as a mere postmaster or conveyor belt when the petition is not against the CJ, in which case his job is simply to transmit it to the CJ to determine if it has merit before a committee will investigate the issues raised. But where it is for the removal of the CJ, he is to consult with the Council of State and may hire an experienced independent lawyer to make the prima facie determination before consulting the Council of State to set up the committee to investigate the case. Anyone who suggests, even remotely, that President Akufo-Addo did anything wrong in this case is terribly ill-advised or ignorant or engaged in self-embarrassing political propaganda. Shraj could also not entertain it because the principle of law is that if the law provides a specific forum or remedy for a particular situation, that is what ought to be resorted to. By Article 146, such a probe is not conducted as Shraj. Section 13 of the Shraj Act also empowers it to reject such misdirected cases. But even if it were a matter it could investigate, it would also have trashed it at the preliminary stage for lack of evidence. Hearsay without more can never be the basis of any serious investigation by any serious body because the end of such futile exercise is known at the start. There is good reason why Article 146 probe is conducted in camera and not open to the public as dictated by the Constitution. If you wish to invoke it, respect it fully and not in part, knowing also that a breach of this confidential rule exposes you to sanctions, including arising from possible criminal prosecution, damages for constitutional infraction, damages from defamation suit, or breach of injunction, or committal for contempt. I hope such frivolous petitions are not the reason presidents have reportedly unconstitutionally refused to act or transmit reported petitions to the CJ. That's my take. That's your legal light. Let's be serious in the Republic. That's where I take a quick break and return to introduce my guest as we begin to ask the three major questions. Will the NDC's electoral reforms proposals survive? Will Agenda 111 pass the procurement scrutiny? And will Shraj give the 7 who were killed in the elections justice? We'll be right back.